co-chair from the Charlotte chapter. And thank you for joining the immigration webinar, which is organized by Telangana American Telugu Association immigration team. And thanks to Banu Illindra Garu, founder and attorney of from BBA Law Group. And our Telangana American Telugu Association is the first Telangana organization in North America and a non-profit socio-cultural charitable organization which is built to promote, preserve, and perpetuate the Telangana community in the US. And TTA organization was formed by a few like-minded people whose leader is Dr. Paila Mallareddy Garu, a billionaire entrepreneur, a harmonious person, but above all, a good Samaritan, who does not let go an opportunity who are in need. And he's very well known for his philanthropic activities and his leadership contribution to the community. So we thank Paila Mallareddy Garu for creating the TTA family. And the mission statement of the Telangana American Telugu Association is Telugu Kalala Tota, Telangana Sevala Kota. Using this as our theme, we are introducing the following strategic initiatives. Like foster the Telangana culture for the next generation through hosting and celebrating Telugu festivals across the country like Batukamma, and protecting our communities in the most vulnerable times by forming a task force and a 1800 emergency hotline as a first-time response. And Telangana American Telugu Association has been forefront to serve the community in need. Our community services works within the core principles of the organization and provide assistance to all the Telugu community across the US as in like areas of emergency services, immigration services, legal, consular services, by facilitating the reach with respect to authorities. And let's welcome our TTA President, Mr. Vamshi Reddy Garu, and TTA Advisory Council, Executive Committee, and all the BODs, RVPs, and TTA members and guests joining for this webinar. I think unfortunately, Vamshi Garu did not join the call as he's traveling, but yeah, his wishes are with us. And our TTA Mega Convention is coming up in Seattle. Dates are from May 24th to 26th. That is in this year in the Memorial Day weekend. So this is the first time we are hosting the Telugu convention in vibrant city Seattle. So please do join us and show some support to us. And today's webinar, Satish and the Jagadish Chinam are the moderators for the webinar. And today we are going to cover the important topics like preparing for fiscal year 2025 H1B lottery, and the topics like H1B cap 2025 registrations and safety, the precautions to take care of it, and the denials of duplicate petitions, and the new H1B restrictions and how they will be beneficial to petitioners, and the latest immigration trends in the employment-based immigration. So the ground rules for this webinar are, please mute everyone and please post your questions in the Zoom chat box. And once after the webinar, we can have a Q&A session so you can post your questions. And now I would like to welcome our Dr. Divakar Janyam Garu. He's our Executive Director from the TTA and he's from the Boston chapter. He's the one who is helping in conducting all these webinars. And yeah, he'll say some few words about our presenter Banu Garu today.
Thank you, Dipti. Good evening. Thanks for joining immigration webinar with a short notice. And thanks for accepting the webinar, Banu Garu. So Banu Garu is an immigration attorney, belongs to BBL group. He has several years of experience and various aspects of immigration law, especially in business immigration law also. And the BBL law group is providing a prompt and courteous and professional service to the clients. And he's helping many organizations. He's helping not a TTA, many organizations helping the community. And Banu Garu, thank you for your service. And particularly in the COVID time, really we won't forget your help, how helped in the community. He worked with the different organizations, different people. He don't care caste and creed. He helped many clients during the COVID time and many advisors, many help. Really, thank you for which I know. Personally, I'm also benefited from Banu Garu. He helped so many queries and so many issues. And BPL group is one of the finest immigration group in Virginia. And Banu Garu, your dedication and service to the community do not go unnoticed. And we're very grateful for your commitment and also helping the others navigate complex immigration processes. And also thank you, Banu Garu, for supporting Telangana American Association last couple of years, is sponsoring for all the convention, other things. And thank you very much for your help, and thank you for support for the TTA community. Thank you, Banu Garu. Thank you. Yeah. So Deepthi, go ahead. Yeah. Mute, Deepthi, mute. Sorry. Yeah.
Yeah, Banu garu, it's all yours now. Yeah, you can proceed.
Thank you, Deepthi Garu. Thank you, Divakar Garu, for your kind and generous words. It means a lot, and thank you very much for that. Before we proceed further with the topics which we intend to discuss today, just want to let you all know that the information what we are providing is meant for general awareness purposes. It does not constitute a legal advice or create any attorney-client relationship. Anything discussed in this call is also not protected under the attorney-client privilege because of that reason. We try to provide as accurate information as possible during this call, but if you need any personal guidance or anything like that, please try to reach your attorneys and get the guidance accordingly. If we are your attorneys, please feel free to reach us privately. Very happy to help you, providing you proper guidance as per your case facts and everything. And I would like to congratulate TTA for its tremendous growth in the past few years, and really congratulate Paila Malla Reddy Garu, and also current President Vamshi Garu and the entire team. They're doing tremendous selfless service till date. And I'm glad that I'm part of the TTA now and in the past also, and trying to help whatever way I can for this coming convention in Seattle from May 24th to 26th, and wish you all the best. I know that this will be very successful event for you all, and congratulations to the entire team for that. And to be discuss the topics, what we want to discuss today is that we're talking about the H-1B cap registrations for fiscal year 2025, and what are the changes and how those changes are going to impact, what steps we need to take, and how we can take, and also propose regulatory changes for the H-1B visa program and other immigrant programs, and how it will impact as an individual and also as a business owners who are dependent upon these programs to hiring foreign skilled workers. First and foremost, let's talk about the H-1B registration program for the fiscal year 2025. The H-1B cap registration is going to commence for fiscal year 2025 on the noon of March 6, 2024, and going to end on noon of March 22nd, 2024. It is very, very important to know the change dates are very different from the past few years, where the registration started on March 1st itself. But this year, the registration is starting on noon of March 6th instead of March 1 of the particular fiscal year. The reason for that is because of the changes implemented, with the regulatory changes implemented with the H-1B program, allowing people to file online and also making it as a beneficiary-centric program. The USCIS wanted every employer to create a new organizational account through their myuscis.gov account. Even though you have a myuscis.gov account for your company, that account will no longer function to submit the registrations unless you create my organizational account again and submit the registrations from March 6, 2024. And the USC is allowing people to register organizational accounts for the companies from February 28, 2024 onwards. So every company who intends to file cap law for the H-1B registration for lottery, for H-1B cap lottery, they have to create an organizational account from February 28th, 2024 onwards. You can register anytime, but it's starting only on February 28, 2024. That's why USC has given 7 days time to submit the lottery registrations for the employers from March 6, 2024. And through this organizational account, not only submitting the H-1B cap registrations, but also you can do online filings like H-1B, I-129s, I-140s, and other programs. So these are the significant changes happening with the H-1B lottery system itself, where you're going to submit the registration and everything. So every employer has to register an organizational account with the USCIS from February 28th, 2024 onwards, so that you're allowed to register and file H-1B cap lottery registrations. You may think that you already have a myuscis.gov account, but that account will not work to submit the registrations anymore for the fiscal year 2025. I'm just repeating what I said right now, just to have a clarity for the individuals. And other thing, very important thing which we have to understand is that for the fiscal year 2024-5, the fee increase for the H-1B cap registration has not happened. The fee increase for H-1B cap registration will come into effect from April 1, 2024. Therefore, it is applicable only for the next fiscal year, that is fiscal year 2026, which will be in March 2025. So for this year, H-1B cap registration, still you are paying $10 fee for each registration to the USCIS. It is not $215, which will be from next year, but this year it is only $10 for each registration which you are going to submit for the fiscal year 2025. Main important thing is you have to understand, and most important things is there are certain required information to submit the successful lottery registration has been changed for fiscal year 2025 than the previous years. The important change is that you provide a minimal information, but now it became mandatory for the employers to submit the passport information of the individual whom they intend to hire on H-1B visa or H-1B status. So they have to provide the mandatory passport number, as well as they have to upload the copies of the passport pages or any travel document of that particular individual based upon the nationality of his country. But most of our community members are Telugu people and also Indian community people. Most of them are from India. Therefore, most of them may have Indian passports. So India does not issue any separate travel documents. Generally, they only issue passport only to show a proof of travel for the eligibility for them to travel across the world. So every employer is required to upload biographic pages of these passport pages of the individual for whom you intend to submit H-1B cap lottery registration, along with passport number in the lottery registration. So these are the basic changes happen from what was in the past, where in the past, we only required to submit minimal information about the employer and the employee, prospective employee otherwise. But now, along with that minimal information, we have to include passport pages and the passport number, which is mandatory, where in the past years, it was only optional. So that is the change we have right now. And other change, which is very, very important thing you have to understand is now, when you're submitting the H-1B cap registration to organizational accounts, by mistakenly, if you're submitting a duplicate registration for the same employee, it is going to notify you that as an employer, you're submitting the same entry which you already submitted to the USCIS for the same individual. Therefore, it can avoid you mistakenly submitting duplicate registrations for the employee so that that entry won't get invalidated unnecessarily because of such error or because of such clerical error that submitting duplicate registrations. Where in the past, we have seen that employers, when they submit the registrations themselves, mistakenly submitting multiple times for the same employee, and accordingly, that registration getting invalidated because employer submitted the duplicate registration for the same individual from the same company. So those are the things or the changes implemented in the system. And one major important thing which we all have to understand for this cap lottery selection process is that we are now, the lottery selection process is happening through now. What I would say is that in the past, until today, it was through employer-centric lottery selection process. What I mean to say that is employer-centric lottery selection process until now. What I mean to say that is that every registration submitted by an employer is considered to be a separate entry for the lottery selection process. What I mean to say that is, for example, if employer A and employer B and employer C submits the lottery registration for employee John Doe, all these are considered three separate entries for the purpose of lottery selection in the name of John Doe. Now, in that way, the probability, the number of lottery registrations are become more for the purpose of selecting. Therefore, chance of getting selected become very less for the individuals who are getting into the lottery. And because of that, because of this multiple submissions and less utilization of the cap numbers, USCIS had to go through first lottery, second lottery, and third lottery in some fiscal years in the past. Last year, we had 2 lotteries because of that reason only. Now, USC is trying to avoid that, trying to see how they can actually limit the possibilities of that many selections and also increasing the chances for the individuals to get selected in the lottery. What the USCIS did is, with the fiscal year 2025 and future, they converted this lottery system into beneficiary-centric system. What I mean to say beneficiary-centric system means, hello? They made it a beneficiary-centric system. What do I mean by beneficiary-centric system means any lottery registration submitted by any employer on behalf of John Doe, only John Doe's information will be taken and entered into the system for the lottery selection purposes as a single entry. So what I mean to say is, for example, employer A, employer B, employer C submits the registration. I'm sorry, I'm getting an echo.
Yeah, let me mute everyone.
Sorry for that. And hope you all can hear me now, because I was also muted mistakenly. And
You're good, Bhanagar. Go ahead.
Thank you, Wendy. So if employer A, employer B, employer C submits the lottery registrations for employee John Doe, only John Doe will be entered into the system, and the lottery will be selected for John Doe. If John Doe gets selected in the lottery, then all these employers, employer A, employer B, and employer C, is notified as John Doe is selected, and these employers have a choice to file an H-1B petition on behalf of John Doe. And John Doe also has a choice either to go with all the 3 employers, or the 2 employers in those 3 employers, or at least 1 employee. This is only for example purposes. I'm telling 3 employers. There is no limit on how many employers can submit registrations, as long as those employers have legitimate offers and their offers are unique and bona fide and separate from other companies. That means these registrations are not submitted in collusion with other employers or sister entities or related entities or affiliated entities or known entities or something like that, which was the big problem in the past few years. And USCIS was very serious on those issues. And we have seen so many cases have been issued NOIR. Around 28,000 cases have been issued NOIR after getting selected and approved for multiple registrations and revoked those H-1Bs by the USCIS. Till date, around 28,000, as per the data they released probably sometime in October or November, as far as I remember. So that is what the major change with this H1B cap lottery registration system. Does anybody have any questions on this H1B cap registration?
So, Bhanugaru, I have one question, and Bhanugaru.
Sure, sir.
Bhanugaru, yeah, I think I'm not very clear about, like, you said like the one employee can apply from 5 different companies and he might get selected from 5 different companies, all 5 or 4 or 3, 2, 1, whatever it is. Still, the chances that employee is taking through different employers increase the chance for him, right? For him or her.
Yes, no, it won't. The reason is he will be entered into lottery only once. Irrespective of how many employers submit the registrations, he will be entered into the lottery only once. That means the probability for him is only 1:2, depending upon how many number of people are applying for the lottery. Previously, it wasn't like that, right? Previously, let's assume.
Oh, okay. Got
Previously,
it.
it wasn't
So
like that. Previously, it was like. Previously, it was like this, right? Previously, if 10 employers submitted the registration, then it was 10 by how many employee and how many more entries have come into the system. Like, for example, last year, 780,000 registrations have been submitted. And let's assume that John Doe had 10 registrations submitted. So his possibility or probability of getting selected is 10 by 780,000 last time. But now it is increasing. It is increasing right now, chances for him, right? Because he has more probability of selections right now.
Yeah. Okay, got it. So it is considered as only one entry, irrespective of number of applications that they made. So
yes.
Got it, sir. Understand. So thank you for clarifying.
Yes. So this actually gives the actual gauge to the USCIS also how many unique individuals have been actually submitted for the lottery registration, and tells them what is the actual demand for this H1B program also, right? And based upon that, probably we will have an opportunity to lobby with the Congress also, saying that, you see, after this new system also, this many individuals, this many requirements have come from these companies. So there is a demand for the H1B program, and the numbers must be increased from 85,000 to 135,000 or 140,000, whatever the reasonable number we think to lobby. Okay, as an organization or as any other thing, we can actually get into that. But that is irrelevant for these purposes, how this lottery works. I just brought that into that issue, which is not applicable here anyway. The main important thing here is that the chances for an individual getting selected more, because he's not competing that many duplicate registrations right now for himself, right? And so that's where the whole probability will increase. That's what the USCIS is believing. But in reality, I do not know. When USCIS is telling that all the 3 employers have an option to file an H1B petition, and they only have 85,000 members, including master's quota, how that will increase the chances for the employees in reality, we have to see. Once we can see the data, then only we can talk about it. They say that they have a very strong algorithm, and based upon that algorithm, they design this program and everything. But, and we have to see how this program in reality really works.
The chances to the employee maybe because he is applying through the 3 ABC employers. So he has a chances to select either of the 3. He cannot work for the 3. So he has maybe that could be the reason that he has the chances.
He can work for 3 also at the same time. There is no restriction for him to work for 3 also at the same time.
Oh, really? Oh.
Concurrent employments, right? Concurrent H1B petitions. So nothing says that cap petition cannot be a concurrent H1B petition. So he has an option to work 3 employers at the same time, or he has an option to work for 2 employers at the same time, or an option to work for 1 employer at the same time. It's all about how he negotiates, how he develops his relationship with his employers, and how he takes his job opportunity. That's what it depends upon in reality. But however, you have to understand this. There is also a problem when of course, employee has a leverage here, as a bargaining power here in the current system, because he has a choice to choose which employer he would like to go with once he gets selected in the lottery, especially when he has a multiple employers filing registration for him. But however, you have to understand this. These employers will also can get into a trap sometimes with the frivolous employers. Right? For example, if he's going with the multiple employers, 10 employers, if some of them are just submitting the registration because they just want to make money on the registration, and they're not really a bona fide entity, or really do not have a legitimate offer for the individual, and if this guy gets selected, and if he gets H-1B filed by one of those employers, he gets selected those H-1Bs, and in the future, if any site visit happens, or if he goes for the stamping at the consulate, they can question him. You have submitted this many registrations. Why did you submit all this many registrations? And if you submitted these registrations, are these all are legitimate? And what USCIS has any information about one of those companies as a bad company, or they flagged that one of those companies in them. And whatever this guy is telling sometimes can conflict with the information what they have, or contradict the information what they have, and that may make them believe that this guy is lying, and that can become a flag on him, right? So under those circumstances, they may not deny his visa under 212, but they may deny his visa under 221G or under 214B. And if they do that, then probably he will not get a visa also. So he's risking in that also falling into those kind of a traps, because we have seen there are so many frivolous employers in this industry. They claim to be an employers, but they are not actually an employers. They try to come up suddenly, open up some mushroom companies, and then make money with the registrations and then shut down after that. It happens. It happened in the past. It can happen in the future too. So employees also have to be very careful when they are going with the multiple registrations with the employers. I don't see anything wrong. I mean, and the thing, it's an employee's right to choose any employer they would like to work with. They cannot be restrained on that. It's a fundamental right. It's a constitutional right given to them under the Fifth Amendment, right to travel. So it is not something which we can restrain or we can control on them. We cannot make them involuntary servitudes for us. But point is, there is always, we have to assess which is proper information, do the due diligence, whether the employee is genuine or not as an employer, and at the same time, when the employer is genuine or not as an employee, and then make a decision what's best for you under your circumstances under this for this H-1B cap registration. But yes, this cap registration is far better. The system, beneficiary-centric system, is far better than what it was in the past for the purpose of employees getting selected more in the lottery. But in reality, we have to see how it will impact the business, how it will impact the employees also in getting H-1B selected. Any other questions with the cap registration? Then we can go on another topic.
Yeah, somebody is asking, and thanks, and Hilendra Garu again for your time.
Yeah.
What is the salary requirement for H-1B specialty occupation?
It depends. It depends upon what position it is, depends upon what location it is, and depends upon what are the requirements of that position are. You just can't tell this is the salary for that position. And because H-1B is also can be either part-time or a full-time. They need not to be full-time all the time. So many factors, and location, all those matters a lot.
Bhanugara, a question for you.
Mhm.
Couple of people, friends, sons, kids, they want to apply from India, H-1B lottery.
Mhm.
So once they get selected, whether is it okay to, what's the process to approve or not, and how they'll come to US,
Sir, this is what I want to talk in the next topic with
Oh,
the
sorry. Okay, thank you.
proposed H-1B regulations, and
Okay.
how those things can impact the possibilities of the employers hiring foreign workers who are in the US and also abroad. It's very, very important. See, the problem is we are seeing, IT consulting business, most of the IT consulting businesses, and I think our Telugu, especially our Telugu community or Indian community, I would say overall, many of the people who use H-1B program, usually they work in the tech industry, IT industry. Majority of them. And majority of them, H-1Bs are used by Indian nationals. That means from India. However, this program is available to everyone in the world, but we Indians actually use this program more because we have a very high skilled talent, and we are very competent in what we do, especially in the tech industry and IT industry. And that's how we get our opportunities to work in the United States, because these companies are willing to hire our Indian talent because they know how good we are with the technologies, especially in the IT side. And because of that, this program became very popular with the Indian community, and we utilize it excessively, very good way to leverage our businesses and to leverage our careers and everything. So what happens is with the H-1B program is, at the current situation is, with the current regulations with H-1B program, requirement is, we do not have to really provide to hire an individual being in the consulting companies, especially when the employees work at the third-party client sites. Most of the IT industry employees are recruited through the consulting companies who actually supplies their employees to the third-party companies to actually do their job. So in IT consulting companies actually use majority of the H-1B visas also every fiscal year. There are almost 1 million H-1B visas, H-1B petitions are filed with the USCIS every year. Those 1 million petitions usually include cap cases, transfers, extensions, amendments, concurrent petitions, change of status. So many types of petitions are involved. So overall, USCIS adjudicates around 1 million H-1B petitions in a year on an average. So all these cases which we are filing is usually, in the past, prior to 2020, USCIS erroneously applied a common law definition of right to control to determine employer-employee relationship, although regulations clearly defined what constitutes an employer-employee relationship, and also statute defined what constitutes an employer-employee relationship for the H-1B purposes. And what is a definition of specialty occupation also has been defined very clearly in the statute as well as in the regulations as well. However, USCIS erroneously used to apply right to control common law definition through Neufeld memo, which is a policy memo, which is not a law or regulatory changes by the USCIS, and they force the employers to provide documents between every entity involved in between to show that individual actually working in the pro-offered specialty occupation at the client location by showing the client requirements and everything. They used to demand, even if you establish one way or other as per the evidentiary standard to the USCIS, still they used to deny, especially in California Service Center, that did not provide client letter or did not provide client agreement, etc., etc., etc. at the time. However, in 2020, because of the IT Serve Alliance, which is a non-profit organization, filed a lawsuit in 2018 against the Neufeld memo and the itinerary memo, which required you to provide definite itinerary in 2017. And based upon the Administrative Procedure Act failures in implementing those policies rather than the substantial rule of law, and they won that case against the USCIS in 2020. And because of that case, USCIS issued a new memo, policy memo, which is called IT Surveillance Memo at the time, by resigning the Neufeld memo and the itinerary memo, and actually telling employers that as long as you meet the regulatory and the statutory definition of employer-employee relationship, and you can show that your company actually required somebody with a bachelor's degree at a minimum for the position which you intend to hire, and the position requires a bachelor's degree at a minimum, and the beneficiary has those qualifications, then H-1B should be approved for that individual. And also, it provides the clarity about the legal benching also. What is the situation when employer is actually transitioning employee from one project to other project in between? That means from one client to other client in between. Then there's a legal bench in between. There is a certain period of time where employee sits idle in the office, and what can be done during the situation, that time. There's provided guidance on that. And that regulations is implemented from 2020 onwards with the USCIS. And we are getting approvals without any problem with the USCIS when we don't provide any client letters or any project documents or anything like that. Of course, at the same time, they increase the number of site visits for the employers, and the employers start being questioned and sometimes asked question erroneously by these officers, and employers would try to handle on their own without having a proper knowledge and how to communicate, and without even having a proper skills to communicate as well. Sometimes they mess up on their own and get the issues with the company and also with the H-1B petitions they filed. But however, while this is happening in the United States, when the companies hide the foreign individuals and then they're going for the stamping, Department of State still demanding to provide the client letters and the client agreements and other things, especially when the employee is going to work at the third-party client side or is going to work for the IT consulting company, which actually petitioned the H-1B petition. Department of State is basically, the consulates abroad are very adamant in accepting that the policy USCIS implemented or the case which USCIS actually rescinding these policies is not applicable to them. They are still following the old rules and regulations and everything. To avoid these inconsistencies and everything, and USCIS realized that they messed up big time, now they basically proposed a new regulations called H-1B Modernization Rule and Integrity Act, Integrity H-1B Modernization Rule, rules and regulations. And first part of that is they try to increase the fee and the H-1B cap registration. Those two items have been already addressed. And the third is making changes to the H-1B program itself. And those changes are going to be very, very substantial for the H-1B program itself. They're trying to change the definition of specialty occupation requirements itself through the regulatory process. And they're trying to demand and bring back the requirements of the Neufeld memo or the common law definition of right to, or employer-employee relationship, where they're emphasizing more on the right to control rather than any one of the factors, which is hire, fire, pay, whatever the factors they are. They're forgetting about all those things. They're emphasizing on right to control. They're trying to bring those changes through the regulatory process. And if that happens, then every employer again is required to provide the project documents, required to provide the client letters, required to show the positional requirements by the end client requirements of specialty occupation. The major issues with that is we have to prove the position requires at a minimum bachelor's degree or its equivalent in a related field of endeavor. And not only that, the salaries also will be very questionable issue here, especially when the client requires 8 years, 10 years of experience, whereas you are requiring, you still want to file in level 1 and level 2 wages of H-1B petition for that particular position. That's going to be problematic. Even if the client letter tells you that the position requires a bachelor's degree at a minimum rather than anything else, but still they will look into the comparable positions available or posted by the client online, and they can question the client by doing a site visit, how this position is not being publicized online, whereas other position with severe experience has been published. Therefore, there can be a discriminatory issues coming to them. Therefore, they're going to go in that way behind also. So these are the complications which we are going to face if the new regulations comes into it. Of course, these are all addressable issues. We handled that in the past. We should be able to handle them in the future. We as an attorneys are very competent to do this. And we have many clients who are the members of TTA, and they know how competently we handle during the Neufeld memo and the interim memo stages also. We didn't have many failures at that time also with California Service Center and other service centers. We were able to successfully navigate through the H-1B petitions and got those approvals at the time. But still, that's going to be a headache for the employers in coming days if the new regulatory regulations are passed and implemented. So these are the changes we have to anticipate coming for the new H-1B cap petitions. But of course, if they're not, then you do not have to provide, until those regulations are passed, you do not have to provide any itinerary, any project document, any client letter, or anything like that. If any other lawyer tells you any other way around, I do not know what to tell about that. Okay? Until these regulations are passed, you do not require to. You can still defend your position. You can still defend your requirements based upon the nature of your business and your past hiring practices or future hiring practices, whatever it is, you can still do that. But that is the complexity over here. That's why what we are advising our clients is take advantage of the current regulations prior to the new regulations are coming into effect. Once the cases get selected in the lottery, whoever employee you intend to file an H-1B petition, file them ASAP. If possible, in premium processing also. Even the fee is very high. Even there's going to be a fee hike, which I'm going to talk in the next segment within the next 2-3 minutes. The fee is going to be very high. Still process them in the premium processing. If we are the attorneys, we will process them as expeditiously as possible. If any RFE comes also, we address those RFEs as expeditiously as possible and get the approvals prior to those new regulations coming into effect, so that you do not have to go through the unnecessary burden to get these approvals. And at the same time, we're discouraging people to hire people from abroad unnecessarily if you have a talent to find and recruit in the US itself. If you do not, for the positions which you have, then it's understandable you're recruiting people abroad. The reason is that you have to go through this scrutiny again, and you have to go through this muster again at the Department of State also. And Department of State again will require and demand, irrespective of what the regulations are, the client letters, project documents, and everything, because the cases are pending in the court. Those cases have not been decided. We do not know when those cases will be decided also. So until those cases decided, Department of State will continue its practice. And if that happens, again, you will have a problem with the 221Gs abroad. And that is the problem if somebody wants to get hired from India these days, unless you have a consolidated real requirement, real need, or if you can document that you do have a project, especially if it's a third-party client, then yes, you can go ahead and hire H-1B workers abroad. I don't see any problem with it. Okay, and there's nothing wrong in hiring H-1B workers abroad, but you have to document your need and requirement, irrespective of what the regulations are at the time he goes for the stamping or she goes for the stamping. So that is very, very important. You all have to understand and remember when hiring foreign workers from abroad this year, only for this year. We will have an idea how it goes after this year, and then we can strategize for next year accordingly. So these are the changes which we are anticipating with the H-1B program in coming days. Because I'm talking only about H-1B programs, I'm not talking about any other program or any other visa right now, because of the segment which we decided to discuss today. We will be very happy to discuss other topics in the next webinar, which we will be doing again every 4th Sunday, I believe, this immigration seminar. Any questions about the H-1B regulatory changes, the requirements of the H-1B program and everything? Then I can talk about the fee hike also and how it's going to impact employers and everything also.
Then some simple questions are there, Andy. So can somebody have a H-1B and B2 visa at the same time? That is one question, and there are 2 more questions, but I can go one by one, or otherwise we can pause and address the questions at the last, whatever you're comfortable in.
Sure. See, individual, I mean, when he says H-1B and B2 visa together means, is he talking about in the visa in the passport or the status in the US? Because there are 2 different things. And if you're talking about the visa in the passport, yes, it's a possibility. You can have a B2 visa and H-1B visa in the passport. Sometimes USCIS will issue 2 visas, but when you are entering into this country, you can only enter on one status into this country, either on H-1B or a B2. You cannot have dual status in this country.
Okay. The other question is, does site visits happen only to the employers, or is it to employees also?
Oh, it happens to everyone. Whenever the site visit is happening, they're coming to the employers, they're coming to the employees, and they're going to the clients as well, and the vendors as well.
Okay. And one last question before I think you can move on, Andy. What is the reason for not to travel after H-1B filing and an application process is in progress?
See, it depends upon what type of H-1B petition you are filing, especially when you're filing for a change of status. The change of status means you are actually requesting USCIS that you are in the United States, you're legally living in the United States in a particular status, like for example, in B1, B2, or H4, or L1, or L2, or some other E visa or E3 visa, whatever status you are in, or F1 or F2, J1 or J2, whichever status you are in, and you are asking USCIS to change their status from that particular status to H1B status in the United States, because you're already in the United States and you're planning to continue to stay in the United States. So when you file for a change of status, you have to continue staying in this country. If you leave the country, that means at the time of adjudication, you are no longer in the United States. At the time of adjudication of change of status, you have to be physically present in the United States as well, per the regulations. Because you're not physically present in the United States at the time of the adjudication, therefore, you basically abandoned your change of status request. Because of such abandonment, your change of status will be denied. Of course, an alternative, if you request for a consular processing, then USCIS may approve it for consular processing if H-1B petition is approvable. That's the reason why if you file for a change of status, you cannot travel while H-1B change of status is pending until it is approved or denied, whatever it is. Hello? I hope I answered that question. And now we can go to the fee hike in the H-1B program, H-1B cap program and everything. As I said, in this new regulations, the two parts have been already passed by the USCIS, that is the H-1B registration process and also the fee increase for all the immigration benefits which we are seeking with the USCIS. And this fee increase has been significantly higher than what it was in the past. Especially H-1B program and the I-140 petition now requires employers to pay an additional asylum program fee if they're filing an H-1B petition or I-140 petition for their employees. This asylum program fee for I-140 is $600 irrespective the size of the employer company, like irrespective of how many employees the employer has at the time of filing I-140 petition. So besides I-140 filing fee, you have to pay $600 in addition to that to get I-140 processed. If you want to do premium processing, the premium processing fee is increasing to $2,805 from $2,500 from tomorrow onwards. From tomorrow onwards, the USCIS fee, premium processing fee is $2,805 instead of $2,500 for the I-140 or H-1B program. So if any premium processing request is receipted tomorrow or after, if they do not include the correct fees of $2,805, their premium processing request will be rejected for improper filing fee. So you all have to understand that. So $600 additional asylum program fee you have to pay for the H-1B program. Why do you have to pay asylum program fee? Nobody knows. Why employers has to take that brunt? Nobody knows. But USCIS reasoning is that someone has to pay for it. So we are asking employers to pay for it. That is the reasoning they're saying. I don't know whether that reasoning is legally acceptable or not. That's what it is. And also, whenever you file an H-1B petition, initial H-1B petition, you have three types of fees you're paying for the H-1B petition all the time. Those three types of fees which you're paying is the H-1B base fee, then the ACWA education and training fee, and then anti-fraud fee. These are the three fees which you are paying always when you're filing an H-1B petition. Initial H-1B petition. Initial H-1B petition means whether it's a new H-1B petition or a change of status petition or a transfer petition or a new concurrent H-1B petition. So when you're filing any one of those petitions, you're paying these type of these three types of fees for filing an H-1B petition. That is H-1B base fee, ACWIA training fee, and anti-fraud fee of $500. H-1B base fee as of today is $460. Anti-fraud fee is $500. And the ACWIA fee varies on the size of the company. What I mean to say is, if the employer has less than 25 employees, then the ACWA fee was $750 as of today. And it is the same, going to be also in the future. If you have more than 25 employees, then the ACWA fee is $1,500. And also, you have another additional fee which you are paying for the H-1B program, especially if you have 50 or above employees in the company and 50% of the workforce of that company is an H-1B program, then the employers are required to pay additional $4,000 besides these three fees when they're filing initial H-1B petition. Additional $4,000 fee is called public law fee. That is mainly meant for the border security. That is $4,000. So if your employee less than 25 employees, as of today, you're paying $1,710 in total H-1B filing fee if it's a new petition. If you're 25 or if you're more than 25, then you're paying $2,460. And if you're 50 above, you're paying additional $4,000 to $2,460. That is, it will be $6,460 as of today. But now, these fees will increase from $620 to $920, depending upon the size of the company for filing H-1B petitions. And these new fees will come into effect from April 1, 2024. What are these new fees are? What is being increased is they increase the H-1B base fee from $460 to $780. That means they increased it by $320. That is 70% of the base fee has been increased. So the base fee is increased from $460 to $780. And then you're paying asylum program fee of $600 if you have 25 or more employees. Okay. And you're paying, if you have less than 25 or less than 25 employees, you are paying asylum program fee of $300. And if you're a non-profit, you're not paying any asylum program fee. This is only for the companies which are for-profit entities. If you have less than 25 employees, if you're filing an H-1B petition, you're paying $300 asylum program fee. If you have more than 25 employees, you're paying $600 asylum program fee from April 1, 2024 onwards. And also you have to remember this asylum program fee you're paying for every type of H-1B petition from April 1, 2024 onwards, whether it's a first-time extension, second-time extension, third-time extension, whether it's a first-time amendment, second-time amendment, third-time amendment, whether it's a concurrent petition, it doesn't matter. Whether it's a non-profit petition, whether it's a concurrent petition, it doesn't matter. You are paying asylum program fee every time you're filing an H-1B petition, irrespective what type of H-1B petition it is from April 1, 2024 onwards. So if you have less than 25 employees, your fee is increasing by $620. And if you have more than 25 employees, your fee is increasing by $920. That means instead of $2,460, you are paying $33.80 if you have more than 25 employees, H-1B filing fee. That is without premium processing and without assuming that employees are more than 50 and you have to pay additional $4,000. And if you are less than 25, your fee will be $1,710 plus $620 will be added. That means it will be $2,330. $2,330, $33.80. And if you have more than 50 employees, if you have to pay additional $4,000, then it will be $73.80. So that is the fee hike for the H-1B program from April 1, 2024 onwards. For I-140, they reduced the base fee from 700 to 535, but they added mandatory asylum program fee of $600. So overall, they're making more than $425 than what you used to pay for I-140 filing in the past. There are several other fees for the H-4s and all these things, but because of the lack of the time, I'm only discussing about the H-1B program fee increase right now. And if anybody has any questions about this, kindly feel free to ask me now. And
Yeah.
we can start the Q&A, Jagdish Garu.
Okay, thanks, and Banu garu. Yeah.
So, Banu garu, a question for you.
Hmm?
I know H1B all increasing. What about green card filing?
That's what I said, sir. For I-140 and 485 also
Okay,
fees
sorry.
increased.
Uh-huh.
For I-140, as I told you, have to pay asylum program fee. For the 485, the fee has been increased quite a lot. I don't recollect exact number, but you should, as of today, you're paying $1,225, but I think you're paying around $1,735 from April 1, 2024 onwards. And also, if you're applying an EAD, as of today, you don't have to pay any fee with 485 when you're applying for an EAD. But at the time, if you're applying EAD along with the 485, you have to pay half of the EAD filing fee. I think EAD filing fee will be off means will be around $320, something like that. So 1,700 plus 320, you're paying almost $2,000 now for 485 filing. I can be wrong with that number. I don't recollect in my mind, but it is extensively, significantly increased for filing 485 from April 1, 2024 onwards. And for I-140 also, same thing. As I told you, it increased around $425. Every petition fee has been increased, but however, you have to understand for certain type of petitions and applications, you can file online. And if you file online, $50 will be reduced than what you file through paper-based filing. But for certain type of cases, we always prefer filing paper-based because there, if you're filing paper-based, we have a room to make a legal arguments. We can show our lawyering skills in certain type of cases. So we encourage certain type of cases always filing paper-based rather than online, because online systems can be glitchy. We see this problem all the time with F1 EAD cards. People who apply F1 cases, F1 students apply on EADs online and filing F1 change of status online, and they do all these things. Because of those glitches, they'll have a lot of problems, and they come to us during that problematic stage. Sometimes it's beyond our control, but most of the times we are able to address them through the RFS, but sometimes they are beyond our control because of the glitches happens in the system. And USCIS won't accept those things and won't admit that there are glitches in the system.
Thank you, Banu garu. Thank you for a very informative session.
Mhm.
And I have a couple of questions received in my WhatsApp message. So what's the status of visa numbers? H1B, B1, B2, they're not moving. So what's going to happen? The next presidency, next government, and the people are concerned about it. H1B, H1B2, B3, the numbers are not moving, So what is
The
this?
numbers are not moving for H1B or for the immigrant visas?
Immigration,
Very different
green card
things.
visa, green card visa.
Yeah. See, unfortunately, we have oversubscription of the program. Even though this year, actually, they did allocated decent numbers for the employment-based immigrant petitions. They've allocated more than 220,000 visas this year. But however, we have oversubscription. That means for Indian per country nationals, because only 7.1% of those can be allocated to the Indian nationals who are subject to the country of birth of India. And we have more number of people in EB2 and EB3 program and EB1 program now because of the EB1C intra-company transfer petitions. That's why we see this backlog for Indian nationals. And I'm not seeing, unless Congress passes any law, until then, I don't think we will see any improvement with these visa numbers moving. But the problem is Congress will not pass anything with the immigration law because it's a toxic subject for them. And probably they want this to be alive for the political gain or for whatever purposes it is. So anything introduced in the Congress with immigration, that bill is dead on arrival in both houses, whether it's in House, Congress, or whether it's in Senate.
Okay. Thank you, Pargar. Thank you very much. Jagdish, you can ask questions here.
Yeah. Few more questions only. Can you explain a little bit more on concurrent H1, Cindy? And the following question is, any new changes to I-40, I-140 and H4 EAD process?
Yeah, let's talk the first one, sir. Okay, because second one, I'm not able to understand what do they mean by that. So I want to discuss that again
Yeah.
clearly. But the first one is concurrent H1B employment. The word concurrent means at the same time. What does it mean at the same time means, for instance, if you're working for X employer as a full-time regular employee, and you have an opportunity, let's assume that instead of saying X employer, I would say this. You as an employee were currently working for Microsoft based upon your H1B petition approval as a regular full-time employee. And you got an opportunity with Amazon. They both are in the Seattle. And Amazon also says that, Mr. John Doe, you are excellent in your profile and everything. We are looking for somebody like you to join our team. We are eagerly wanted to hire you. This is the package we will give you, and we want to hire you at the same time. And you have a great opportunity, great position with Microsoft, and you do not want to let go of that position. At the same time, you do not want to lose your opportunity with Amazon also, which is coming to you. So what will you do? You want to work with Amazon also at the same time. You don't have any problem managing both the jobs at the same time. Then you go to Amazon and tell them, see, this is what my situation is. I'm with Microsoft. I can't lose the job because the job has a significant prospects for me. And it's important for me to keep the job for my family, keeping the best interest of my family. But if that is okay with you, I still want to work with your company. And I want you to process my H1B petition as a concurrent H1B employment petition so that I can work for you as well at the same time while I'm working for Microsoft. And if the Amazon agrees to that, then Amazon will file a petition as an H1B concurrent employment petition. Rather than a regular H1B petition, they'll file it as a H1B concurrent employment petition. That is the options which you choose in the form I-129, and you prepare your case accordingly. You state about the concurrent employment nature of the job, and then accordingly you file H1B petition. So once the petition is received, you can start working with Amazon because H1B portability regulations will be applicable over there. Therefore, while case is received, you can start working for the second employer. That is what the H1B concurrent employment is. But during this employment, whether you want to disclose to your main employer, your regular employer or not, it's up to you. I mean, because that's a contractual obligation between you and your regular employer, whether to disclose whether you're working with the second employer or not, but it is not an immigration requirement. Okay.
That's great, Andy. Thank you. Another question, Andy, related to example you quoted on John Doe. If he can choose one or more employees after H1B approval, and can he get a multiple paycheck at once from multiple employers?
As I said, if the multiple employers, if some of them file as a concurrent employment, then he can get multiple paychecks from multiple employers. If those employers files a regular H1B employment, then he cannot work for multiple employers at the same time. He has to choose which employer he would like to work with. So at the time of filing of an H1B petition, it's very important to choose what type of job it is, whether it's a concurrent H1B employment job or it's a regular H1B employment job.
Great.
Banugaru, one question, Andy. What are the chances of getting into the law? Recently, there was one proposal of the bill which they recently announced about kids on H4 status who have more than 8 years will not age out.
It's dead on arrival, sir. It's dead already in Senate.
Oh, okay.
Trump made it fail because he felt like Biden and his administration will get the credit for those things. So he made ensure that Republican senators won't pass that bill.
So at this moment, there are no hopes on that bill.
No hopes. It's dead.
Okay.
It's dead. It's gone already.
Okay, and the next question. Any cost changes for EAD and AP renewals?
Yes, there is a cost change, but I don't recollect in my mind. I did not keep the fee list in my head in front of me. I'm sorry for that. Yes, there is a cost change on that. I can publish that later on in the TTA immigration group.
Okay, then that's
And you asked about the H4 EAD process and I-140 process. What is that question? I didn't understand.
yeah. Basically, his question is during the concurrent H1s, can employee allowed to work more than 40 hours a week, combined companies? I think
Answer is yes. There is no limitation on how many hours an individual can work. It's up to the individual's choice how many hours he wants to work. For instance, if you're an ER doctor, you are on call 24/7. So it's all about the nature of the job. There's no limitation on H1B on how many hours you can work. It's up to an individual how many hours you can work. And most of the H1B workers are also exempt employees. Therefore, employers need not require to pay overtime, but they have to pay, if they consider to be full-time employees, then they have to pay 40 hours per week, irrespective of how many hours they work in a week.
got it. Yeah. The other question related to that EAD, you mentioned that there is a new bill on H4 EAD. Without EAD application, H4s can work. Can you
No.
please? No. Okay.
There's nothing like that. It's dead on arrival. There is no such kind of that bill. As said, the bill which other question was asked about the child,
Yeah.
children on H4 above 80 years, they are there. They can get work authorization, everything. In the same bill, there was a proposal about the H4 program also, saying that they do not have to separately apply for H4 EADs. They can, based upon the status, incidental to their status, they can get a work authorization if I-140 is approved for the principal beneficiary, right? Just like how L2s and E3s can get work authorization incident to their status. They do not have to separately apply for EADs now, especially L2S and E3S. That means L2 spouses and E3 spouses. So, but that bill was dead on arrival right now. So don't know whether that will be passed or not. But that will be a very wise reformation, wise policy change or regulatory change, which USCIS can do if they want to do it. USCIS has an authority to do that. It doesn't have to go through the Congress for that. Hopefully, USCIS will do that in the future.
Got it. So there is a question. I'm not sure this is incomplete, but he mentioned that Murthy firm filed a petition to count only beneficiary for issuing the green card. Can you please share your thoughts? Because
The case, I do not know much of details about the case because just not only Murthy law firm, there are several lawyers filed the cases like that, and all those cases are pending. What they're asking is the only principal beneficiary should be counted towards the cap, the number, visa number, rather than the dependents. But the point is that authority is given to the Congress to determine whom to count, whom not to count. It is not the USCIS and as per the statute. So I do not know how much tooth we have in those cases, but it's a great effort. I think it's a great point. They're filing a litigation. If the court decides anything otherwise, who knows? Anything can come in from the courts, right? And then there is a reason behind them. There's a procedural policy issue is there behind them when they made that argument in the courts in these cases. So they're very viable arguments. So I hope those arguments are heard by the court and court gives favorable decision on that. And I think it's a logical sense also. It makes sense also for them doing that. Because you just can't waste 4 immigrant visa numbers for the family members because it's automatic that family members migrate along with the principal beneficiary. I think it's a very common sense regulatory change which they're seeking, and these cases are really good ones. Let's support all these cases, whatever cases there. I think there are more than 6 or 7 cases pending in the courts in the various circuits.
Okay, thank you. The next question is, can someone travel while H1B extension is in progress and have validity for current H1B visa?
Answer is yes. If H1B extension of status is pending, answer is yes, because they already have an H1B status. They do not have some other status. They're not seeking change of status. Therefore, there is no abandonment of status over here. Okay. Only the time you'll have a problem not to travel is when you're applying for the change of status, because you're seeking a change of status because you are in this country. For the extension of status, it's okay under the portability rules.
The next question, Andy. Thank you. A person with H4 EAD is allowed to do 2 IT jobs for 2 different companies.
It's a universal work authorization. They can do whatever they want to do. There's no limit on how many jobs they can do, how many businesses they can do, whatnot. They can do anything they want to do, which is legal, which is a legal job or legal business.
Okay.
Sir, one question, Andy. Can
Mhm.
I
you
ask
please
one question?
post, Veeragaru, can you please post it in the chat, Andy? There are more questions came before.
Sure.
Thank you, Andy. Application for E3 to green card, do they need to be on H1B? What is the process maybe?
That's a great question. A lot of people have this question, these doubts and everything, because E3 visa is not a dual intent visa. Unfortunately, these are treaty visas, e-visas, and they're not dual intent visas. What the regulation says that they cannot file for adjustment of status in the United States, E3 visa holders. But however, we have seen many times we file adjustment of status for E3 visas and they've been approved. But most of the times they're required to go abroad and apply for a immigrant visa and then enter into this country. But they can process their labor certifications, their I-140s and everything. And see, this is what I'm really sorry to bring this one right now. In the next seminar, which we have next 4th Sunday, let us talk more about NIW I-140s, O1 visas, and EB1A and EB1B categories, how people can take advantage of those programs and get their immigrations done in this country. Let's talk more about that. Let's talk about more about evidentiary requirements for that. Let's see how people can meet into that. Especially, they can take advantage of O1 program if they haven't. See, H1Bs are limited in a year, right? And if they don't qualify for L1s, at least they can try for O1s and get selected O1s, especially for the STEM degree holders. These days, we are seeing a lot of leniency by the USCIS in approving O1 visas for them. And also NAW I-140s also for them. Okay. Lots of STEM degree holders are getting NAW I-140s approved from our office and from other places also. So I would love to discuss more about those issues, those topics in the coming webinar. And then we'll talk more in detail, because I think that will be very useful for the members, I believe, those things.
That will be great, Andy. Thank you. Other question is, employees who are working for multiple companies through concurrent H1Bs have a limit on the number of hours per week?
We already answered, sir. There's no limit.
Yeah, the same, right? Yeah, okay. Yeah, Veeragaru, if you're okay. You can ask the question, Andy. Yeah.
Yeah. So we have this pilot program to do the stamping in US, right? Last month. Is there a possibility that gets extended to more people so that we can do the stamping here?
Absolutely, yes, because it's a pilot program. They're testing the system and everything right now. Their intention is to open it to everyone and all types of visa categories. And they're very positive with what's going on. So it's going to happen. But the timeline, I cannot tell you right now because I don't have the specificity on that. But this year, it's a testing phase for them. But I'm hoping that by the end of this year, I think we'll have more clarity how soon they will open for everybody. But because they have to hire that many people, it's a costly. It's a cost and result solution basically for them.
So right now there is no news about further program, right? Right now.
Right now, no. But the thing is, we will get it. I mean, right now, only certain particular window people only can apply right now. So basically, what they're doing is they're releasing 2,000 slots every month. Right? There are only 20,000 visas available. So they're releasing 2,000 slots every month for Indian nationals and 2,500 for Canadian nationals. Okay. So hopefully we will see how many people are applying for this, because the window they've given is only 1 year for the Indian nationals, right? expecting that those many people will be there from India to apply for the renewal, because that many people have been already stamped in the India for the H-1B visa. So now they only opened it for the H-1B renewals for the individuals who have been stamped visa from particular day to particular, that is in 2022, from one day to other day, 2022 or 2021. I don't remember the exact date.
21, yeah.
Yeah, 21. Yeah, exact date. I'm sorry. Only for the particular window. But they're going to expand. I'm sure that it's going to expand. Their intention is to open for everybody.
Okay, thank you.
Thanks, Bhanugaru. There are a lot more questions, but I'm taking unique questions, Andy. So can any individual file an GC extension independently, or they have to take assistance from the attorney to file?
What do you mean by GC extension? I didn't understand. For the I-90 renewal? You mean to say they already have an approved permanent residence card and they want to apply for the GC renewal because it's expiring after 10 years? If that is the case, I need to see, anytime you all have to understand this. You can always represent on your own. Constitution guarantees you right to represent on your own. Lawyers are your agents. Okay. The reason why you hire a lawyer is because they're specialized in the nature. If you're capable, you can treat your own cancer. But you don't treat your own cancer. You go to the doctor, you go to the oncologist for that reason, because they are specialized in treating the cancer. Because you know how to do chemotherapy. If you do chemotherapy and if you do it in the wrong place, you'll be the one who will be suffering. Same thing, this one also. If you want to file on your own, yes, you can do. You're welcome. And be ready to face the consequences also tomorrow if you do anything wrong with it. That's the reason why it's always advisable to use the experts in the field of endeavor in which what they do. You do your job, what you are better. That's the way. That's why it's important for us to understand where to spend money, where not to spend money also. And it's all about spending money. We will spend money on 18 years of Macallan's, but we won't spend money of $300 to the lawyer for the I-90 renewal. That tells us exactly where our criteria and priorities are. We have to understand our priorities. Important is to handle this thing. We have to change our priorities also. I think it is about our cultural issue main rather than anything else. We all came from middle-class families in India. We're very conservative in spending. But we don't know what to prioritize in spending, even now also, after being this many years in the US. And so with your question, answer is yes, you can file on your own if you want to. Anytime, you can represent on your own. If you have been charged with murder tomorrow, you can represent on your own. But will you do it on your own, or will you hire a defense attorney who is really good with defending murder charges? So it's all about your choice.
Thank you, Bhanugaru. Thank you, Bhanugaru. Very good explanation. Yeah.
Diwakar garu, time check, and we have a few more questions.
Okay. 2 more questions, then we can close.
Okay.
Thank you, Bhanugaru. Sorry for taking a long time. Yeah.
No, it's fine, sir. I'm fine, sir. Today's Sunday anyway, so I'm fine.
I'm taking some questions who was newly asking, so that everybody get an opportunity.
Sure.
So advanced payroll renewals now take significantly longer, ranging from months to years. If advanced payroll renewal application is still pending, can I have a family emergency that requires me to travel to India immediately? What will happen without consulting a lawyer? Can I return to the United States any other way?
Unfortunately, if you do not have an H-1B visa or L-1 visa, you cannot return any other way. But you have to understand this. When you have an emergency, you have a solution for it. USCIS do provide solution for you. It asks you to go to the local USCIS office and show them the emergency required documentation and everything, so that they can give you emergency travel document. Of course, it will be valid only for one time, and it will be valid only up to 45 days because it's emergency in nature. But you have an option to get that advance payroll. I personally did recently 5 cases for the emergency situations where their parents passed away. So I had to go to a local office. We did not take InfoPass appointment or anything like that, because there's no possibility of getting InfoPass appointment.
Yeah.
So we have to go locally and then talk to them, harass them, shout at them, so that they let us in and process our advance payroll. And it happens. I mean, they will try to stop you, but you have to be persistent and be aggressive, be persistent. You don't have to be aggressive, be persistent that you need it because of this emergency and everything. And especially if such an emergency comes to you, if somebody passed away or anything like that, they're very, very considerate. I have a lot of respect for the USCIS. They adjudicate so many cases. For example, if you really look into the number of cases they adjudicated in 2023 was remarkable. They have adjudicated 10.8 million cases. Usual average is 7 million to 8 million cases. And also, if you look into certain cases like naturalizations and immigrant petitions and EADs and all these things, processing times have been reduced significantly by the USCIS. Unfortunately, not for the advanced payroll yet, but I'm hoping that it will happen. And this is what even confirmed by the Doug Rand in one of the conferences I recently attended with the AILA. Doug Rand is the advisor to the USCIS director, and he's the actually number 2 in the entire USCIS after the director. And he basically said that they're working really hard to reduce the number of processing times for these cases. But it all depends upon how many people they can hire and train as quickly as possible, because it's all about the adjudicating officer availability. On average, they take 10 to 12 minutes a case to adjudicate. That's it. So it all depends upon how you present your case matters a lot, because he's making decision 10 to 12 minutes whether the case should be approved or denied.
Okay, Randy. Next question. What are the consequences if a person applies multiple H-1B petitions?
The consequences is it depends upon how the multiple applications are. The consequences is you can be arrested, you can be debarred, you can be removed, and all those consequences are there, especially when you willfully misrepresent the facts about the H-1B filing, saying that you have a legitimate offer and a bona fide offer of employment. Legitimate offer, and you're going to hire that individual in the position offered, especially when you collude with other employers, because you're trying to take undue advantage of the lottery system and you're denying the opportunity for other person who's legitimately trying to get selected in the lottery. You're usurping the opportunity, and unfortunately, that is the thing here. It's all about whether you're legitimately trying to get into the lottery or you're trying to take undue advantage of the lottery by misrepresenting the fact. And that is the issue comes with the multiple registration.
One more question, and two more are there, but we'll take a different question. A person on H-1B goes back to India, and if he has to come back after 1 year to the same employer or a different employer, does he have to go through the lottery again?
If he has a remaining period on H-1B, for example, if he only utilized a certain number of years in H-1B, he did not utilize all 6 years, then he is not subject to the cap. He can recapture the remaining period and then come back to the US. Only the time he will be subject to the cap is when he exhausts 6 years and he doesn't have an I-140 approved and the visa numbers are not available for him.
Hello?
If the visa numbers are not available and if he has an I-140 approved, even if he exhausts 6 years, still he is not subject to the cap because he can seek 7th year extension and come on H-1B.
Okay. Pradeep, do you have a question? Pradeep, can you please go on? Thank you.
Sorry.
Jagdish, go ahead. Pradeep, is any questions, Pradeep? No.
One.
Okay.
No, Divakaran, actually.
No problem. Thank you.
Thank you.
Jagdish, okay. Any questions?
One more question we'll take. If H-4 EAD person is applied for H-1B and his H-1B lottery is picked, when he can work again for H-4 EAD, or how many days he has to work on H-1B after it is picked up?
I didn't understand the question at all.
Yeah, okay. I'll repeat, and I think this is a little long question. If H-4 EAD person is applied, Veera, you are there? Oh no, this is somebody else. If H-4 EAD person is applied for H-1B and his H-1B lottery is picked,
it's H-1B lottery picked, but H-1B lottery picking up has nothing to do. Does nothing. If the employer files an H-1B petition And if the H1B petition is approved, especially if they file for the change of status for the H1B, and if the change of status is approved, then they are an H1B from that day onwards, from the day the change of status comes into effect. That is usually October 1 of that particular fiscal year or later. Okay. And so H4EAD has to continue to work. If they want to work, they need to have a continued work authorization until the date change of status comes into effect, whether it's on October 1 of that particular fiscal year or later, whichever the start date of the H1B change of status petition is.
Okay. Yeah, go ahead.
Jagdish, I think any more questions? No more questions. No.
Yeah, I think there is one more, but I think that's not clear, Andy. Yeah,
Okay.
otherwise we are good, Andy. Yeah.
Okay.
Anybody has any questions? One last call. You can unmute and ask very quickly if you have any burning question. Okay, that's good. And this is Banugar, very valuable, Andy. Thanks for all your answers and patience. And
Sure.
yeah, over to you, Diwakar Garu.
Yeah, thank you, Banu Garu, for the valuable information to the community. Now, I would like to request Anita Garu give vote of thanks. Anita, can you start now? Thank you. Yeah.
We are excited to share that Telangana America Telugu Association hosted a successful immigration webinar. It was an insightful session packed with valuable information that can benefit everyone looking to enhance their understanding of the economic field. Thanks to Banu Garu for the immigration webinar to the community. Your insights and wealth of information related to immigration were truly invaluable. Not only did you provide in-depth knowledge, but you also took the time to answer the questions from the audience, making the session even more enriching. We are grateful for your excellent talk on H1B CAP 2025 registrations and safety precautions, denials of duplicate petitions as well, new H1B restrictions and visa numbers. Your expertise and insights were truly invaluable to the community. Thanks to our TTA President, Vamshi Reddy, Mr. Naveen Reddy, and AC, EC, BODS, and TTA members. Kudos to the moderators, Atish Narlavar and Jagadish Chinnam Garu, who tackled the entire session well. Thank you for your tremendous efforts in organizing and executing the event successfully. Thanks to Deepthi Garu for the introduction remarks, and thanks to everyone who participated in the immigration webinar. We appreciate our Executive Director, Dr. Diwakar Chandyam Garu, Executive Director of TTA, the TTA Boston team, and Deepika Reddy, social media team, for their outstanding work and dedication. Stay tuned for more upcoming webinars and empower yourself with the knowledge and tools to make informed immigration. We appreciate your interest in our webinars and look forward to welcoming you to our future events. Thanks to the one and all who joined the immigration webinar. Thank you.
And a quick question, Andy. Sorry, a lot of people are asking Banugar details. Not sure everybody able to see the chat window, but Diwakar Garu, can you post this message and I can't copy for some reason? Or whoever co-host or host, please copy and paste to either WhatsApp group or wherever they can get this information.
Okay. You can't do anything now? Okay.
I can't do, but once Deepthi Garu, if you can do it, or anybody can please.
Yeah, definitely.
I posted now. Okay, thank you. Yeah.
Hope all of you can see the information. Please reach out to Banu Garu if you have anything. Thank you.
And thank you, Madhu Maladi, social media team, for helping us. And thank you, Deepthi. Thank you, Jagdish. Thanks for everyone. Thank you. Okay.
Thank you, Andy, for the work. Thanks, everyone.
Thank you all. You all have a wonderful night.
Thank you, Banugar. Thank you.